For more than 47 years, our nonprofit, Resources for Seniors, has supported older adults and caregivers in Wake County. We can help in many different ways, including adult daycare programs, ramps and repairs, in-home supports, and consultation and referrals. Indeed, we're who to call when you're not sure who to call. Resources for Seniors stands ready to support you in your caregiving journey.
I'm Mark Costley, the founding attorney of Clarity Legal Group, the Triangle Area estate planning and elder law firm. You know those people who become overwhelmed dealing with the multiple challenges of being a caregiver? Clarity Legal Group helps people establish legal tools that avoid confusion, give them peace of mind, give them asset protection, and in some cases help them qualify for Medicaid. We help people get it right in the face of some of life's most important challenges. We don't just provide wills, trusts, and powers of attorney. We provide solutions and ongoing support. We provide clarity and peace of mind. It would be a privilege to help you.
Are you like 80% of seniors who would like to age in your current home? Call Wisdom Senior Care. Are you currently taking care of a loved one and finding yourself frustrated, tired, and even lonely? Call Wisdom Senior Care. Always available, dependable, and flexible. Come partner with Wisdom Senior Care, keeping wisdom at home.
Hi, I'm Mark Costley, an attorney at Clarity Legal Group. I'm here today with my colleague Jonathan Williams, who I'll introduce in a second. We're going to talk with you about trusts and how they can make a difference. We really have a commitment at Clarity Legal Group to the caregivers community. We've been sponsors of the Triangle Caregivers Conference for a number of years, and we've even published a caregiver's guide, which you can access on our website if you're interested. That's claritylegalgroup.com. I'm Mark Costley again. I'm the founding attorney of Clarity Legal Group. I've been practicing law for better than 30 years. We work in the area of estate planning and elder law. I went to college at Duke and law school at Duke and went straight into private practice and have been doing it ever since. Number of attorneys in the firm, but Jonathan Williams is with me today. Jonathan's one of our lead attorneys in the estate planning and elder law areas. He's a Wake Forest grad. He's going to be part of the presentation today. I think you're going to enjoy what he has to say. There are lots and lots of different kinds of trusts. We're not even going to begin to cover them all today, but we are going to focus on some of the basic and most pertinent trusts to the area of caregiving. We're going to talk about revocable living trusts, which are a basic management tool. We're going to talk about irrevocable asset protection trusts that can be used as part of ordinary estate planning or even asset protection planning in association with elder law. We're going to talk about Medicaid trusts and special needs trusts. So let me give you some basic sort of terminology before we get into this too far. You know, there are what are called inter vivos trusts and testamentary trusts. An inter vivos trust is a trust that's created while someone's alive to be used for them while they're alive. A testamentary trust is one that comes into existence only at the point of their death. So we might think of a testamentary trust as being built into a will. So the trust says, or rather the will says, instead of giving my property to my children, give it to a trust for my children. But we also might find a testamentary trust built into an inter vivos trust, which we'll talk about today. Two other big picture distinctions, a revocable trust and an irrevocable trust. And that distinction really is kind of what it sounds like. A revocable trust is one that can be changed or modified, and an irrevocable trust is one that is not subject to being changed or modified by the person who created it, except under very limited and special rules. An irrevocable trust is thought of as a separate legal entity, and a revocable trust is almost always thought of as, in some ways, the alter ego of the person who created the trust in the first place. So let me talk a little bit about what a revocable trust is and how it works. I want you to think of this kind of living trust, this inter vivos trust, as a box. It's really just a place to put your assets, to organize them. So assets that you have now aren't changed. They aren't transferred to a trust company or an institution. They're just changed by being put in the box. We're going to change the way they're owned. So it's still the same checking account. It's still the same investment account. But many of your assets are going to be held through this box in a centralized organized tool. The trust has three people of responsibility, or three positions of responsibility in connection with it. There are trustors or grantors. Those are the people who create the trust and transfer their assets into this box. There are trustees, the people who are in charge of the box. They are in charge of managing and taking care of the things in the box and taking things out and using them for the third position, the beneficiaries. So there are specific people designated in this trust document for whom the assets can be used. With this kind of revocable living trust we're talking about, it turns out that when it's created, usually one person is in all three positions. A person who is the grantor takes their own assets and puts them in the trust, serves as the trustee of the trust, and is the beneficiary of the trust, at least during their life. So again, we're not talking about bringing in a trust company. We're not talking about changing what you own. We're talking about organizing it in a fashion that's going to be really effective. So what living trust planning is really about is planning for the efficient and effective management of your estate. We can use it as a valuable tool to avoid guardianship, to avoid probate at death. We can avoid court fees and legal fees associated with administering the estate at death. But most importantly, we ensure smooth access to all of the assets in the trust in the event of your incapacity and at death. Then this same trust can provide these testamentary trusts, these trusts that arise at your death that provide asset protection or protection from remarriage of a surviving spouse, divorce of children, creditors, or other people who might try to take advantage of the people you leave assets for. So remember, this revocable living trust created while you're alive is really just a contractual relationship. It is a legal agreement between the person who creates the trust and anyone who serves as the trustee. Now, once you set this up, it's not going to change much. The people who set it up can do anything they want with the assets in the trust, typically. The trust becomes irrevocable at death and then sets out rules for a successor trustee, a person chosen by you who follows those rules, which typically say pay my creditors, pay my funeral expenses, my debts, my taxes, whatever expenses of my estate that exist, and then distribute the assets to people you've named, or perhaps distribute the assets in further trust for the benefit of those people. So a living trust has multiple lives while you're alive and well, and then it's managed by someone of your choosing if you experience incapacity and can't manage it yourself during your life. And then at your death, this trust becomes irrevocable, meaning no one can change the rules, and you have testamentary arrangements that says who gets the property, how they get it, when they get it, and who's in charge of making it happen. These trusts are highly customizable. If you're ever doing work in connection with estate planning or ever thinking about setting up a trust, you should run screaming from anyone who sort of treats them all as fungible and every trust is sort of the same. A trust is built around what's important to you and can have highly customizable provisions. Our clients tell us that the most important thing to them are not really their money always. Often it's family, it's their health, their friends, their values. Relationship issues for survivors who they leave behind. People don't want to leave a mess. People want to make sure they get it right. Our number one client concern is making sure that people pass on their hard-earned wealth without court interference. People want to make sure things go smoothly and that things don't get tied up. Second concern is to avoid any unnecessary taxes. I've got a lot of clients who don't want to pay any taxes, but I don't have any clients who want to pay more taxes than they have to. And so managing your affairs correctly can avoid payment of unnecessary taxes and certainly unnecessary court fees and expenses for things like lawyers, accountants, and bonds and other things. Third client concern is to protect assets from medical expenses or other creditors. We don't want to be in a situation where the family runs out of money because of the huge burdens of healthcare costs. Fourth concern, after people are gone, they want to make sure that their family, the people they love, the people who they leave their assets to, are protected from people who might take advantage of them. This could be people who might try to steal their money or swindle them, but it could be just as simple creditors or even a divorcing spouse and the lawyers who manage that process. Our fifth client concern is people want to make sure that they don't leave conflict among their children or their other beneficiaries. They don't want people to get in conflict over how it worked. And the way you avoid that is you have clear instructions set out in a legal document and hopefully are in relationship with a law firm that is there to say, this is why it was set up this way and this is how it works. So a living trust, this kind of revocable trust I've been talking about, can play a role in addressing each of these concerns. Remember, with a trust, you're planning for what happens both in the event of incapacity and at death. I'd like to tell you getting the document was enough, but it's not. Having a trust is not enough because all of estate planning, whether we're talking about with a will or a trust or anything else, is just as much about how your assets are owned as it is about how the legal documents read. In fact, you can have a will or a trust that says exactly what you want, but doesn't do what you want. How could that be? That's because the legal document doesn't control whether or not a particular account or asset is controlled by it, but rather something outside of the document, which is to say the way it is owned controls whether or not it's controlled by your will or your trust. So if you don't have your assets set up to be in sync with the legal documents, you don't really know what they do. So you can even go to a lawyer, and the lawyer can prepare a will and do it just right, but the lawyer won't know what it does if the lawyer hasn't talked to you about what you own, how you own it, and what it's worth, and made sure that adjustments are made to the way those things are owned so that the plan works the way you intend. So the magic is how you hold title to your assets. And this is true whether we're talking about a checking account or a piece of real estate or anything else. It turns out that in the event of incapacity, in the event of managing assets for someone else who's lost their own ability to do it, this ownership issue is just as important because it defines whether or not things are controlled by a power of attorney or a trust or some other arrangement. All of this makes the trustee selection just critically important for how a trust works. So you want to make sure that you're in charge of who will take care of things if you can't take care of them yourself. So that could be in the event of your incapacity or at death. So who are you going to pick? Well, you're going to pick people that you trust. You're going to pick people who would exercise their judgment similar to the way you would, but mostly you're going to pick people who you have confidence in. So typically, if there's a married couple, they might serve as co-trustees of a trust to begin with the provision that if either one of them fails to serve, the other becomes the sole trustee. And if both of them fail to serve, they may have, perhaps the wife's sister or a sibling who will take over and serve as trustee, or maybe an adult child, or even the oldest child first and the younger child as a backup. But your document is going to name who the trustees are, and if you're working with us or any good lawyers, they're going to help you select those trustees very carefully. One of the things about picking a fiduciary, a trustee, or a power of attorney is that making sure that you have the right person picked also keeps the wrong person from stepping up and trying to get control of the assets. And I know a lot of you have experienced those kinds of challenges. So having a legal document in place and the right people empowered will solve those problems. Now, trustees manage things after your death, the person you've chosen, and they get direct instructions in your trust document. And it will typically say something like, after my death, the trust is irrevocable. You can't change the rules, but one of the rules is that I want you to pay all the debts and the taxes. If there's real estate, I want you to sell it, but I give you the power to improve it before you do. You might need to paint the living room. You might need a new roof because the realtor says you'll get more money than you'll spend doing those things, so you want to do it. The trustee is in charge of managing the assets and making sure that they're not exposed to unnecessary risk while getting ready to make the distributions that you've defined. With a trust, this all happens privately. It all happens within the family or the people you've chosen. There's no court auditing of this process. There's no court approval, and the trustee controls the timing. My own father named me as his successor trustee. I didn't do his trust. He had a law firm who did it. But when the time came for me to take over managing his affairs due to his incapacity, he just named me as a co-trustee, and he and I did it together for a few years. He got to the point where he couldn't do it at all, and so for the last couple of years of his life, I did all the management of his trust and payment of his bills and the kinds of things any caregiver does. After his death, I've got one sister. His plan said, my mom had already died, his plan said to leave everything equally to my two kids. And so the question is, when do I make that transfer? Well, in this case, I transferred a large part of the estate to my sister and me right out of the trust within a couple of weeks of the time he died, and then I held the rest to do what? Well, to manage these obligations I had, to pay the debts and taxes, to take care of the house and improve it and sell it. And so we were able to do that on a timetable that made sense for the family and made sense for the particular assets we had. Now, when we think about how people inherit, that's where a trust becomes incredibly flexible, because sometimes we don't just want to give it to people outright. This might be because they're minor children who can't inherit outright, or it might be because they make poor decisions and we want to have someone else make decisions for them, or it might be because we're trying to help them. So it might be that if someone dies and has a trust and they leave a surviving spouse, instead of just leaving the money to the spouse, we leave the assets to a trust for the spouse. This is built right into the revocable living trust agreement that was created in the first place. And it says that the assets are for the benefit of the spouse, that the spouse is the trustee, but we establish protection. The trust says who the assets can be used for. Who are the beneficiaries of this new testamentary trust for the spouse? And typically that's going to be the spouse and any shared or common children they have. What can the assets be used for? Typically whatever the spouse needs, but not for other people or not for extreme extravagances. And then we might say who inherits at the death of the spouse. We control that. So the surviving spouse has his or her half of the estate, but the half that belonged to the first spouse who died is earmarked to go to the beneficiaries chosen before he or she died. Now, the best thing about this trust is, in addition to supporting the spouse, it can protect the assets from his or her creditors and make sure that the assets stay in the family. So by keeping assets in the family, we make sure that the plan and its integrity is honored. In fact, sometimes, we don't do this all the time, but sometimes we say to that surviving spouse, we expect you. In fact, we put this in the document because the first spouse to die says this, we want you to have a prenuptial agreement if you ever remarry, because we want to make sure that the assets are protected for the kids. And we can just put that in the trust document and require that as a requirement of the spouse to continue to be the trustee. Remember those positions in the trust: the creators of the trust, the grantors or trustors, the husband and wife, the trustees, the people who control the assets, and the beneficiaries. So we're not going to say, if you remarry, you are no longer the beneficiary. We're going to say to the spouse, if you remarry without a prenuptial agreement, you're no longer the trustee, to make sure that we preserve the integrity of the assets for the kids. Now, in providing these protections for the spouse, don't sell short the value of creditor protection, okay? We can structure this trust so the trust is not available to the surviving spouse's creditors. If we thought the surviving spouse might need Medicaid in the future, we could structure the plan so that instead of going into just a simple asset protection trust, it goes into a special needs trust under the spouse's will, which would cause the assets to be not countable for the purpose of qualifying for Medicaid, something that Jonathan's going to talk about in detail in a few minutes. Now, the trust is a management tool in the event of incapacity. When I first started practicing law, I kind of scratched my head at why a trust was better than a power of attorney for managing assets in the event of incapacity. Now, having done this for nearly 30 years, I can tell you that there's a significant advantage to using a trust. Now, you still need a power of attorney because the power of attorney is going to control the assets that aren't in the trust, but things are going to be easier to manage in the event of incapacity as a successor trustee than they will a power of attorney. So suppose the surviving spouse gets Alzheimer's disease and starts to have problems. Who's going to be in charge of the assets? Well, that's going to be the successor trustee as to the trust assets, the agent under the power of attorney as to the assets outside of the trust. Well, both these people, the trustee and the power of attorney, are carefully selected by the people creating the trust. Again, it might be a spouse, an adult child, or a close friend. Which legal arrangement controls what? Again, the assets titled under the trust are controlled by the successor trustee, but there are certain assets that are just never going to be owned in a revocable living trust like this. An IRA, a 401k, a life insurance policy, or a life insurance annuity, those are going to be outside of the trust agreement, and therefore, if there is an event of incapacity, that's controlled by your power of attorney. Now, it may not surprise you that often the trustee and the power of attorney are the same people. But when it comes to dealing with that third party, the financial institution, you've got to be using the right legal arrangement, and that legal arrangement needs to specify exactly the right powers so that we know we can do the things we want to do. Now, some things don't relate to finances. They relate to legal affairs, like dealing with tax matters or a dispute or something like that. Those things, during a period of your incapacity, are controlled by the agent under the power of attorney. There's one big difference about these fiduciaries, the power of attorney and the trustee, that is important to appreciate. The power of the agent under the power of attorney goes away with someone's death. So at the instant of someone's death, the person who's the power of attorney can no longer act. The trustee's powers can continue. So if someone other than the grantor is the is the trustee, when the grantor dies, they continue to be the trustee. There's no delay, there's no freezing of the accounts, there's no problem accessing the accounts, but the accounts controlled by the power of attorney are delayed until we can administer them separately. And it's not clear, it depends upon the kind of asset who's going to administer those. It may be the beneficiary under a 401k or a life insurance policy, or in some cases it could be the executor under a will. Now, When we're doing planning, we're almost always thinking about avoiding guardianship. Guardianship is one of the big burdens that we sometimes have to work with for our clients. It is a court process that has really no upside other than making sure that people are protected. But it involves loss of control. It involves typically multiple court proceedings, a lot of delays, a lot of costs and expenses. There are attorney's fees. There are annual audits of the guardian. It's something we'd like to avoid for sure. Well, not only does a trust avoid this as to trust assets, but with a trust and power of attorney, often we can confidently say we've avoided guardianship. I want to also talk about co-trusteeship as a way to provide real value in the event of declining capacity. So we've talked about incapacity. You've heard me throw that term around, and we all deal with people who are suffering from incapacity from time to time. But most people don't just sort of drop off a cliff and they're suddenly incapacitated. They have a period of declining capacity. And in my experience, one of the natural reactions for a lot of people who have an experience of incapacity is to try to hold on tighter to control, right? You feel yourself struggling, you feel yourself forgetting things, you want to control things a little tighter. It turns out, and I say this to my clients all the time, it turns out the best way to keep control is to share control in that situation. What I mean by this is that often when someone's got a bank account controlled by a power of attorney, the bank may take the position that, well, for the power of attorney to take this over and for this to become a power of attorney account, the principal, the person who owns the money, is kind of out of control, and we substitute your control with that of your power of attorney. With a trust, you can take your successor trustee, let's say that adult child or sister that you've named, and say, hey, I'd like to name you as a co-trustee, a simple amendment we do to the trust. And now the two of you have control together. And so as the person who created the trust in the first place declines in capacity, it turns out that they continue to have as much control as they can exercise, and the co-trustee can take care of things as needed without ever getting a doctor to certify that they're incapacitated or incompetent, because they've been elevated to this co-trustee position voluntarily by the person who created the trust. Again, keeping control by sharing control. Another big advantage of a trust is probate avoidance. So probate is the court-supervised process of managing assets at death. Everything that goes through probate is just by necessity delayed and slowed down. It costs money. It takes time. There's literally no upside to probate. A trust is a great way to be very strategic and thoughtful about kind of creating a will substitute, a legal document that steps in and does the things we expect the will to do. Again, as I mentioned before, what the trust says is, at my death, pay all my obligations, and then this is who I want you to distribute my assets to, and this is who I want you to distribute them to. When you die and you have a trust like this, it may be that there's some assets that were outside of the trust during your life that come into the trust at your death. This is very common for something like a life insurance policy that wouldn't be owned in the trust, but the money might be paid to the trust as the beneficiary at death. This is also true for something like a 401k or an IRA, which sometimes names the trust as the beneficiary. You want to be careful about doing that, but we do it all the time when we have a good reason to do that. So we're getting a larger pot of assets in this centralized management tool, but we're doing it all outside the court process. So we maintain family privacy, we reduce the cost, we reduce the need for legal fees, and in fact, we get a better outcome for the family in almost every case. So, what's next? What's next is to begin to think about what happens for the next generation, children or whoever else might inherit from someone at death. So now, if we're a single individual, we're talking about at your death, or we're talking about the death of the second spouse where there's a married couple, who's going to inherit and how are they going to inherit and what kind of protections can we provide for them? Well, the truth is, people have a lot of concern about the financial maturity of their kids, and that really doesn't stop. We think, well, gee, maybe a 21-year-old isn't mature enough to manage all their assets. They might make some bad decisions. Well, I'll tell you, in my experience, I got a lot of clients who think their 45-year-old kids don't make great financial decisions, that they spend money in a way we didn't spend money, right? And so part of that's a generational difference. Those of us who had parents who grew up during the Depression had that instilled in us, right? Take care of all of your money. Be very careful and don't spend money unwisely. And so people who are now in their 40s and 50s and 60s see their children spend money and they just inherently react and say, well, they're not being very, very wise. But in truth, a lot of them really aren't being wise, and so it's important to know the difference. It's a huge concern for our clients. Top 3 risks that we're planning for kids in particular are the possibility that you leave an inheritance to your son or your daughter and they end up getting divorced. What happens then? Well, the worry is that some of your hard-earned money will end up going to your former son-in-law or your former daughter-in-law. Don't love that idea, right? Second thing is that people might try to take advantage of them when they get an inheritance. If everything is done through a will, there's a public record down at the courthouse that says exactly who inherited, how much they inherited, and when they inherited, and so that makes them vulnerable to people who might try to take advantage of them. Biggest problem probably is creditors, lawsuits, things like that. Maybe a child already has tax problems or already has a judgment even before the death of a parent. Well, those assets are going to be immediately available to the creditors if the child inherits outright. And of course, anything that happens to the child in the years after they inherit is also makes the assets available to the creditors, unless, of course, we plan to avoid that. If you take nothing else away from this presentation and you have children or other people who you really care about, I want you to know that getting asset protection and divorce protection built into a plan for them is really a pretty easy thing to do. So it's really hard for me to take my own money and put it in a pot and say, I can still control this, but my creditors can't touch that. That's not really an option for most people. It's something that people with a great deal of wealth can do, but only at great expense. But when we're talking about how someone inherits, the truth is, it's just really pretty easy for me to structure a legal document, again, typically a trust, that says that the assets are available to the person who inherits, to the adult child. They might even be their own trustee, but that the creditors, the divorcing spouse, can't touch those assets at all. So this kind of trust, this beneficiary trust, this asset protection trust is kind of like a tube of toothpaste. Think of it as inheriting in the tube and squeezing out whatever you need with the idea that anything that's still in the tube is protected from creditors, protected from a divorcing spouse. Well, so that makes it really important. Who's in charge of squeezing it out? And that's the trustee. Who's it squeezed out for? That's the beneficiary. When we're talking about this kind of trust for an adult child, it can be the case that if they make good decisions, they're the trustee and the beneficiary. So this is built into the revocable living trust we're talking about. So we might provide divorce protection so that if maybe an adult daughter goes through a divorce, the assets she inherited from her parents are not available to the creditors. Maybe an adult son makes bad decisions. The assets in a trust are completely protected from his creditors, including the IRS. And not just creditors that exist at the time of your death or the principal's death, but creditors that come up over the course of the son's lifetime. We might also just create an incentive trust. We might say, hey, we want to create a trust that incentivizes behavior for a child or other loved one who hasn't been behaving great. We'd like them to go back to college and graduate. We'll give them a graduation gift from the trust upon graduation. We'd like them to hold down a full-time job. So we'll say the distributions that come from this trust are going to be to match your W-2 statements at the end of the year. We might say for someone who has a substance abuse problem, we'll pay for you to go into a rehab program, and if you're successful in that, we'll support you thereafter. So there are lots of things we can do to incentivize folks. And then, as I mentioned, we could plan for a special needs trust for a spouse. We can also do that for a beneficiary. In fact, it's critical that we do it. If we don't, then those beneficiaries are going to be subject to losing whatever government assistance they are receiving as a result of the inheritance. It's a simple plan to make sure they have a special needs trust that protects them. So this kind of trust planning can be kind of a centralized one-stop solution for all of the kinds of things I talked about. I'm going to turn the floor over now to my colleague, Jonathan Williams, who I mentioned before. He is going to talk about the kinds of trusts I haven't talked about already, the Medicaid Planning Trust and the Special Needs Trust in much more detail. So, Jonathan?
Thank you, Mark, and hello to everybody. I'm going to start by talking about Medicaid Asset Protection Trust. Of course, before we can understand how Medicaid Asset Protection Trusts work, we need to know a little bit about Medicaid. Medicaid is a federal program. It's a need-based government program to help pay for long-term care expenses, typically nursing home expenses. In order to qualify, you have to be below a certain threshold of resources. And so, if you're above the countable resource limit for Medicaid, then you're not going to qualify. One of the key rules in Medicaid eligibility is known as the 5-year look-back rule. And that's a rule that a lot of people have heard of. And the rule is put in place so that I can't simply give all my assets away to my children and then turn around and apply for Medicaid the very next day and be able to say that I don't own any assets and therefore I'm eligible for the benefit. Lawmakers decided that wasn't a really fair way to set up the program, so they instituted this 5-year look-back rule. And the rule says, well, when you apply for Medicaid, we're going to look back 5 years and we're going to find out if you've made any gifts during that 5-year period. And if you have, then we're going to create this penalty period. And the penalty period means, yes, you're eligible, but we're not going to pay out the Medicaid benefit until you've served out the penalty period. In the meantime, you're going to have to find some other way to meet your long-term care costs. Typically, that would mean relying on other family members who can chip in until the penalty period has been completed. Well, that leads to the question, what if we have time? What if we don't expect to need long-term care for the next 5 years and we have the opportunity to make gifts ahead of time that won't be penalized under a 5-year rule? Would it be a good idea to give away assets more than 5 years prior to when we expect to need Medicaid? Well, yeah, in some cases that is a good idea because that gift won't be penalized because it comes out prior to the 5 years. Now, how would we structure such a gift? We could simply give those gifts to our children or other loved ones who we want to inherit from us and say, here you go, I'm going to go ahead and give you these assets now instead of waiting until my death. But there's some significant disadvantages to that. For one, there's some capital gains tax issues. You lose the chance to get an adjusted basis. That's a little bit technical, but there are other problems as well. What if you give your assets to your child and then your child gets sued? What if your child gets divorced and we have this situation where assets that you've given to them is now caught up in their divorce proceeding or in some sort of lawsuit that they're involved in? This is a bad outcome. What if I have a child who lives in town who helps me with my bills and my money and finances, and I have other children who are out of town who are less involved? I might want to make that gift just to the child that I work with regularly and that I have a high degree in trust in, but it might be my intention that all of my children inherit equally from me. Well, how are we going to square it that I've given some of my assets just to the one child and the other children don't have the same gift that they receive? You wind up working on the honor system where you hope that the child who you trust will share those assets after you're gone with your other children. Now, in many, many families, probably most families, that's going to work out just fine, but enough families have problems with that, not to mention the other disadvantages we've already talked about, that there is a better way to do this, and that's the Medicaid Asset Protection Trust. Medicaid Asset Protection Trust is an irrevocable trust, meaning once you make the trust and you put assets in the trust, you can't make changes to it after that. You can't pull the assets back out of the trust once you've given it to the trust. The trust operates as a separate legal entity. So if I believe that I won't need long-term care in the next 5 years and I make a gift of my assets to this trust, they don't belong to me anymore. They belong to the trust. Now, there are some rules involved. We need to make sure that whoever is the trustee of that Medicaid Asset Protection Trust is someone other than me. I can't serve as trustee of that trust, but that child that I rely on who lives in town, that would be a great candidate to be a trustee of a trust like this. And even though I might give assets to that child, they don't own it personally. They only own it as trustee. So I don't need to worry about them getting divorced. I don't need to worry about them getting sued because, again, those assets don't belong to my child. They belong to this trust that my child's the trustee of. So we don't need to rely on the honor system either because the trust is going to say, after my death, we're going to divide all the assets equally among all the children and not just the one who I made trustee. We can also structure such a trust so that we can get the basis adjustment and so we don't have the capital gains tax issues that I mentioned earlier. So there's a lot of advantages of the Medicaid Asset Protection Trust. A couple other rules. Once I've given these assets to the trust, they don't belong to me anymore. So I am not able to benefit directly from those assets. I can't pull them back. I can't get payments from the trust. The only kind of interest that I have left in this trust, if I want to retain it, is the right to receive income from the trust. That would be interest and dividends on any investments. It would be rental income if I have rental property in there, farm income, timber income. So any income that's generated by the trust, I can retain that as my interest in the trust, but I can't get the assets back, only the income. But that income right also includes the right to live on the property. So I may give my personal residence to a trust like this and retain the right to live in it, and that's perfectly fine. I'm not trustee of the trust, but I can retain the right to live in that property, which can be a great feature as well. Now, so how it works, I name my trusted child or other loved one to hold the assets as the trustee. Typically, I would be the beneficiary as to the income, but I would not have access to the principal, the assets that are in there. The beneficiaries for principal are typically going to be my children or selected loved ones who I eventually want to inherit from me. And oftentimes the property that's put in such a trust is just held there indefinitely, and it's held to generate income during the remaining years of my life, and then upon my death, it's going to pass on to my family members as I have set out ahead of time. Now, if needed, the trustee can make distributions of principal to my children. Remember, I said I'm not the beneficiary as to the assets in principal. My children or other loved ones are. So the trustee could make distributions to a beneficiary like that. And that way, if I start to run out of money and I'm not able to pay my own bills, then my children would be in a better position to be able to support me if they also are beneficiaries of the assets in the trust and could potentially draw on those assets if they need them. So that can work well. Well, what if I need Medicaid? What if I set up one of these trusts and then I have some sort of stroke or some other medical event that causes me to need skilled care earlier than I expected? What happens then? Well, there is a way to get rid of the trust. We could essentially terminate the trust and distribute all of the assets to the children or other loved ones. But then we'd need to rely on the honor system that the children could then give those assets back to me and thereby eliminate the penalty period. Because if I make a gift to this trust and then I receive those assets back at a later date, then that penalty period can be reduced because I'm wiping out some of those gifts that are otherwise on the record. So this trust does have some flexibility like that for it if needed. That's not the ideal, but it can be taken care of that way if needed. So the last benefit I'll mention about the Medicaid Asset Protection Trust is that there is no estate recovery claim. So Medicaid has this program where after you've died, they can present themselves as a creditor in your estate and get paid back at death from any assets that are in your probate estate. Well, if I've given my assets instead to this Medicaid trust, then upon my death, the trust controls where those assets go. They're not part of my probate estate, they're not subject to my creditors, and they're not subject to a Medicaid claim. So there's a ton of advantages to using a Medicaid Asset Protection Trust if we have the proper time and really can expect that we won't need these funds in the next 5 years or won't need to apply for Medicaid. So we like that trust a lot, and we use it for clients who can benefit from it. Now, the other one that I'll talk about, and this will close us out today, is Special Needs Trust. We also talk about Supplemental Needs Trust, and the first thing I'll say is that those terms are pretty much interchangeable. Some attorneys or governmental agencies will refer to Special Needs Trusts, some will call them Supplemental Needs Trusts, but they really mean the same thing. The goal of a Special Needs Trust is to create a trust for someone who has a disability and who's on means-tested, need-based government benefits like Medicaid, also supplemental security income, which is SSI, comes from the Social Security Department. Those benefits are means-tested, meaning if you have more assets than you're allowed to have, then you get kicked off the program. So like Mark mentioned, we sometimes have a situation where family members will leave assets to someone who's got a disability and who's on these benefit programs, and the result is they lose their benefits, they've got to spend all this money on their own care, and then they go back on the government program, and you really haven't benefited that person very much because they're getting the same services that otherwise would have been provided by the government anyway. All we've really done is save the government some money by paying for their care for a period of time. A better outcome would be, why don't we have these assets in a fund that can be used to supplement what the government provides and increase the quality of life of that beneficiary over and above what they're already getting from the government. And that's what the Special Needs Trust does. In order to do that, it's got to meet some important requirements, which I'll get into here in just a minute. Let me talk about the two main kinds of special needs trusts. There's a first-party special needs trust and there's a third-party special needs trust. I'll start with the easy one. That's the third-party special needs trust. That's the one that Mark mentioned. That's the one I've already talked about a little bit. That's where someone leaves assets for the benefit of someone else who's not them, but who has a disability and who is on benefits. We can leave assets to a special needs trust. The main requirement here is, one, the beneficiary can't be trustee of that trust. We've got to have a third-party trustee. And then secondly, the trust has to be set up in such a way that it cannot replace payments for what the government has already provided. So we have to be able to say that these funds are not available to provide what the government provides. They are only available to provide over and above what the government provides. And that way they can retain their eligibility for the government benefits and then have this extra fund of money that can pay for additional things to enhance quality of life further. So that's the third-party special needs trust. The other one is a first-party special needs trust. That's where if I have a disability and I have some resources but I want to get on benefits, how do I protect my assets? That's the first-party special needs trust. I can create my own trust that protects my assets and allows me to continue my benefits. Now, because that's a little bit more of an advantage for somebody to save their own funds, there are more rules. This is more heavily regulated. There's a couple of additional, in addition to what I've already talked about, there's a couple of additional rules, including that this sort of trust ordinarily can't be created for anyone who's over the age of 65. It's really aimed for folks that are younger than 65. And then furthermore, there's a payback requirement, which means the trust has to say, this is what it does during lifetime. It's going to provide benefits for the beneficiary, but when that beneficiary dies, the first beneficiary who can receive payment from the trust after death is the government. So the government gets paid back for what they've provided during lifetime. And as long as that payback requirement is in there, and then we follow these other rules, then generally we're going to be okay with a first-party special needs trust. So let me sort of walk you through how this works out in the real life so you have a sense of how these things really work. A first-party special needs trust. The paradigm example here is someone who is disabled, they have funds or they receive funds either through inheritance or through some sort of legal settlement, and they're on benefits and they want to keep their benefits and not lose them. A very common scenario would be a personal injury settlement. So if I'm driving down the road, I get injured in an automobile accident, I now need to get on benefits because of my disability that results from the injury, but at the same time I've got this money coming in from a legal settlement because I was able to get liability from the person who injured me. Well, I can take the funds that I've received from this legal settlement or this legal judgment and put them in a first-party special needs trust so that I can keep my benefits, but also have this other pool of funds that I can use for other things over and above what the government provides. So that's the paradigm example. And the goal would really be that I'm able to use these funds and spend this money through my life so that at the time of my death, there's really not much left that would be subject to a payback requirement. It's really meant to enhance my quality of life and not really for future beneficiaries. So that's how a first-party special needs trust typically works. Now, the paradigm for the third-party special needs trust, that is the paradigm we've already talked about, which is where a parent or a grandparent or spouse of someone who needs government benefits wants to leave funds for the benefit of that person, but doesn't want to mess up their eligibility for government benefits. So a third-party special needs trust would be created often as a testamentary trust, so it would be created under a will or under a revocable trust, so that it would come into existence at the time of the grantor's death and would be there to receive funds for the benefit of the person who has the disability. But prior to that, it wouldn't exist. It would only exist upon death. But that's not the only way to do it. We could also do it as a standalone inter vivos trust, a trust that's created during lifetime and exists as its own separate entity, and we don't need to wait for somebody to die to create this trust. And that's more common when we have, let's say, maybe a developmental disability for a child, and they've got lots of aunts and uncles and cousins and grandparents who want to chip in to provide funds to enhance this person's quality of life. Well, we might create a standalone trust that is there to receive those funds and can be used as a special needs trust throughout the lifetime of that beneficiary. So that's another great way to use special needs trust. I will note, as Mark noted before, if you're making a special needs trust for your spouse because you want your spouse to be able to qualify for Medicaid after your death, that can't be a standalone inter vivos trust. In order for that to be effective, it has to be a testamentary trust, and it has to be created under a will. It can't be created under a revocable trust. There's no particular reason for that other than the fact that that's how the rules are set up, and so we've got to follow the way that the Medicaid rules have been drafted. But the great thing about third-party special needs trusts is that there's no gift penalty under the 5-year look-back. There's no payback requirement here because I'm not dealing with my own money. If I'm the benefits recipient, somebody else has left money for me, and so I don't have any obligation to pay that back to the government because I haven't taken advantage of this first-party special needs trust that I mentioned earlier. So special needs trusts are another great tool if you have someone in your life who has a disability or might need long-term care under Medicaid or supplemental security income. This can be a very important part of an estate plan to make sure that we're getting the best outcome for our beneficiaries.
Thank you, Jonathan. I wanted to step in to draw this together a little bit, to talk about the things we didn't talk about. When you have a presentation that talks about trusts, we get tied to the focus of the presentation, but I want everybody to understand that when we have time to plan, when we have the opportunity to be thoughtful and be comprehensive about planning, there are other legal arrangements that are key to making the trusts work the way we'd like them to work. So you heard us talk about powers of attorney quite a bit during this presentation, and the power of attorney is important because there are assets outside of the trust that you might have, like a revocable trust or a Medicaid trust, and we need to be able to manage those in the event of incapacity. But it turns out that a good power of attorney is actually key to doing comprehensive planning, and we want that power of attorney to be tied into the trust. By that I mean, if you get a trust as part of your planning, you probably need a new power of attorney because we want the power of attorney to address the rights of the principal as to the trust, so that the power of attorney specifically mentions the trust and gives the power of attorney agent the authority to exercise the powers of the person under the trust. The other thing is that when we're thinking about the kind of Medicaid planning that Jonathan talked about in connection with the Medicaid trust, well, that's not going to cover all the issues, is it? The Medicaid trust is going to be right for some people and not others, and it's certainly going to be right for some assets and not all of the assets, even for the people for whom we use this. So what do? Well, we want to make sure that we have a power of attorney, and if we've used a revocable trust, also a revocable trust that has provisions in it that empowers the trustee or the power of attorney agent to do some Medicaid planning. What am I talking about? Well, I'm talking about possibly forming trusts. So we might want to give the power of attorney the ability to form a trust for someone if they are incapacitated. But also I'm thinking about the possibility of changing the way assets are owned, creating shared interests, making gifts and transfers, all calculated to deal with the morass of the Medicaid qualification rules that Jonathan talked about. The point here is to remember that just like a trust controls only what a trust controls and a will controls only what a will controls, a power of attorney controls only what a power of attorney controls, and the multiple documents need to work together. They need to work together, and they need to be done in a thoughtful way that reflects that they were done to accomplish the same goals. So sometimes when I work with a client, I'll do planning for their health care. I'll do planning for their long-term care. I'll do planning for Medicaid. But other times we'll say, what if we need this? And we'll say, okay, we want to make sure that the people you name in your documents as fiduciaries, trustees, and powers of attorney have the power to do the things necessary to help you. Now, when you're doing the planning, where does all this start? it all starts with the question, what's important to you? And then it goes to the question, what are your big concerns and how do we address them? Typically, as you can gather, we're going to be using a multiple document, multiple approach strategy to do this, but it does all center on how the assets are owned. So if you're working with us or working with any good law firm, you've got to ask the question, how do I need to change the ownership of assets? If you create the revocable trust that we talked about, we have to transfer the assets into trust ownership. That means changing the way accounts are owned. It may mean deeding real estate. And you want to be working with a law firm that will take a hands-on approach to doing this. So at Clarity Legal Group, we will actually do this for you. But no matter who you're working for, or who you're working with rather, you need not to just leave that to chance. Because as I said before, if you don't have the assets that need to be owned by the trust, the plan won't work as intended. If you don't have the assets transferred into the Medicaid trust that Jonathan described, it definitely won't work. If we've set up a testamentary special needs trust to direct certain assets into that trust, well, the way those assets are owned determines whether or not they'll actually be directed into the trust. So it becomes a very holistic approach, but it also becomes a very practical approach. We want to make sure that the paperwork at the bank, the paperwork at the insurance company, the paperwork at the custodian of the IRA is in sync with the legal documents, so the plan works the way it was intended. Because if we don't cover that part, the asset organization part, we don't get the whole picture. So when we think about Clarity Legal Group, what we're trying to provide for our clients is clarity. And part of that clarity comes from making sure that the legal documents that are necessary to accomplish your goals are in place, but also that the way your affairs are organized are in sync with those legal documents. We're going to go ahead and turn this over to a brief question and answer session, and Jonathan and I would be happy to answer your questions.